Hi, I'm Noah Sachs, professor at the University of Richmond School of Law, and this is the Synopsis. Today I'll be discussing two cases that will be decided by the Supreme Court this term. We expect the decisions in June. And these cases, they may seem like they involve a small issue on the surface, but actually they could be landmark decisions in American administrative law. And they could affect the powers and capabilities of U.S. federal agencies, from everything from food and drug law to energy law to securities regulation and healthcare law. The cases are called Loper Bright Enterprises versus Raimondo and Relentless versus Department of Commerce. And they both involve the same issue. They were brought by the owners of fishing boats. And the owners are challenging a requirement that was imposed by the National Marine Fisheries Service that the fishing boat operators have to pay the salaries of federal observers who will be stationed aboard the boats. And these salaries can be as much as $700 per day. So they strenuously object, and they say that this federal agency has no authority under the relevant law to require them to pay the salaries. So that's the surface level issue. The deeper issue that's at play here is the fate and status of a 4-decade-old doctrine called the Chevron Doctrine, which came out of a case called Chevron versus Natural Resources Defense Council, decided in 1984. And that doctrine is really a landmark in American administrative law, one of the most frequently cited cases by the Supreme Court of all time. And what that doctrine said is that when Congress writes a statute, the courts are there to enforce the statute as written. But if the statute is silent or ambiguous on a particular issue, then the court should defer to the interpretation of that statute that's given by the federal agency that's set up to implement that statute. So in this case, what that would mean is that the National Marine Fisheries Service would have a lot of leeway to decide whether these fishing boat operators have to pay the salaries of the federal observers or not. If the Chevron Doctrine applies, then the courts would probably uphold this requirement to pay the observers. And in fact, that's what the lower courts did. They applied the Chevron Doctrine, and they said that the agency wins in these two cases. But now the Supreme Court has taken the case, and every indication is that the court took these two cases for the purpose of overruling the Chevron Doctrine from 40 years ago. The Chevron Doctrine has been under attack, particularly by conservatives and particularly by the conservative wing of the court. And based on the oral argument, every indication is the court will either overrule Chevron or scale it back dramatically. My guess is that this is going to be a 6-3 decision in favor of overruling Chevron. So the real question for American law, for citizens, is what comes next? If Chevron is overruled, what would that mean? And what I expect will happen is that once Chevron is overruled, it would mean that judges and courts will be much more in the driver's seat of interpreting what complex federal statutes mean. And for conservatives, they say that's as it should be. That is the role and function of the courts. But there are some dangers that lurk in that direction as well, which is that when we look at really complicated statutes governing things like food and drugs or nuclear energy or securities regulation, that in many of those cases, the agencies themselves are in a better position to develop interpretations of federal statutes that will work for regulating those kinds of industries. If judges step in, they may get it wrong. And I'm concerned especially about a kind of lock-in effect where judges will interpret what a statute means, and that interpretation will stay on the books potentially for decades, making it harder for agencies to adapt the law as new problems arise. So this pair of cases is really critical for the future of American law, for separation of powers, and for the balance of power between the judicial branch and the executive branch.